1,700. So, and the rate at which I said is approximately 10. That calculation I have given. The total number is 4,41,000.
No, what is the financial year? 19, 20, 21, which?
3 years I have given. What I can do, Milord, subject to my lord's kind approval, Milord, I can put it by way of a supplementary affidavit. They can take instruction and give a reply also. Because the basis which they have shown is a target fulfillment. They have certain, the district has certain target.
No. I am on point number 2 at page 8. You accept that notification that this is the rate of the cess and royalty.
Page 8 of the supplementary report.
Supplementary report, page 8. Rupees 83 for royalty, rupees 15 for cess.
Yes.
This you accept.
Yes.
Only thing is the calculation has to be made. How much you have produced and how much you have extracted, that has to be clarified.
Kindly come in deep. What I'll do then, I'll take instruction also on this. I'll prepare a supplementary affidavit based upon the calculation and the calculation sheet which I have handed over to your lordship, because that is exactly the calculation and amount of earth which I have excavated. Based upon this, I'll serve it to them. Let them file a reply to this.
Yes.
Let them assert it.
Whatever they have stated, the calculation sheet or assessment, that is their personal record. That may be correct, that may be wrong. But my lord, if my lord kindly come to the writ petition, I want to just submit in a very short form, my lord. If my lord kindly come to their prayer of the writ petition, my lord. Their prayer is, my lord, against the demand. They have sought for a read. I am reading, my lord, page 11 of the writ petition. A read in the nature of mandamus, commending the respondents, in particular the respondent number 4, they are main agents, servants, and or subordinates from giving any effect, further effect to purported notice of demand, such and such. That is my lord, demand notice. Next is, my lord, the commending the respondent in particular that the subordinate to consider the representation made here by your petitioner, my lord, which is at page 46. My lord, if my lord kindly see, my lord, last order pursuant to which I have filed the supplementary affidavit, here, my lord, and also in this writ petition, petitioner's primary grievance is that the demand notice has been issued by fixing the royalty and cess without giving opportunity to the petitioners, and the demand notice has been issued without considering the lockdown period, and also the demand notice which has been placed and demanded of the petitioner is baseless. There is no base. That is 3 or 2, my lord, points. If I satisfy my lord, then perhaps he may not have any case. Now, my lord, you kindly take, my lord, my supplementary affidavit. For this, my lord, I have to read. My lord, first paragraph, page 2 of my supplementary affidavit, my lord. Paragraph number 1, I am reading. I am not reading, my lord, because pursuant to which order I have filed the supplementary, it is stated. Now, my lord, Roman 1, page 2. That the demand, but kindly, my lord, what I have stated, my lord, kindly the 2 or 3 points is main in this petition. That the demand of royalty and cesses of Greek art were generally fixed up after taking a nuanced approach in a meeting held in the presence of all stakeholders and or interested parties. And for the same, general notices, not any individual notices. General notices of the meeting has been duly circulated to all the owners as well as the associations. To which the owners is, my lord, attached. They are owners on behalf. And this is the usual procedure. In the financial year 2019 and 20, such meeting was held on such and such day, wherein either the respective owners or the representative of the respective brickfield association, including the association to which the petitioner's brickfield belongs, So, my lord, the petitioner Brickfield to which association petitioner belongs, they also have been, my lord, properly noticed and signed the attendance sheet. So, my lord, if my lord kindly, after reading this paragraph, kindly come to my lord page 7 of my annexure. This is the my lord meeting resolution of 16/9/2019. The rate meeting has been my lord duly occurred. The rate has been fixed at page 8, and my lord kindly see the page 10, that is the attendance sheet. My lord kindly see serial number 11. Sheikh Idris Ali, I have stated in my affidavit after affirmation that the association to which the petitioner belong, the representative of the association has appeared in the meeting. So no opportunity has been given that matter goes, because on behalf of the petitioner, association has been given opportunities. And my lord, if my lord kindly see, there are several associations or representative, including the government representative, who have signed up to my lord page 30.
Page
30. Page 30. This is my lord attendance sheet for the financial year 1920. 7 to 13. So all the Blickfields owner or association, my lord, were duly noticed and they were present. Now, my lord, kindly take paragraph Roman 2, my lord. It is submitted that financial year 2021, now we are on 2021, was experienced with COVID-19 pandemic, and the Brickfield owners and association demanded for reduction of modalities. So they have demanded the following following the aforesaid usual procedure of my lord, giving notice. The meeting of modalities fixation for the financial 2021 was held on such and such day, wherein in presence of the respective Brickfield owners and association on behalf of the owners, the district authority was pleased to fix the royalty and cesses same as it was fixed on by the previous year 1920. Now is very important. Whether the COVID period has been considered or not, one of the point of the petitioner. But later on, the state appropriate authority further reduced the royalty and cesses by a memorandum number 15/2021, which was almost half of the royalty and cesses as it was fixed by the district authority in the meeting held on 22/12. So, considering the COVID period, the difficulties of all the stakeholders, the appropriate government, my lord, by issuing notification, have reduced the demand to the 50%. Finally, the royalty and cesses were fixed 1,30,000 CFT of bricks are transferred. If my lord kindly come after reading this paragraph, page 14, my annexure. Page 14, my lord, I am showing the meeting resolution of my lord 2021. As usual procedure, the meeting was held. That is the page 15, my lord. The rate is fixed. And my lord, page 17, my lord, page 18 is the attendance sheet of all the owners or association on behalf of the owners. They have attended the meeting, they have signed the meeting. So, no opportunity in fixing those two financial years demand, that is goes, my lord, because opportunity have been given and there is no specific denial before my lord that no, I have not appeared in this meeting. Can you consider this? Now, my lord, next page is page 22. That is the my lord notification which I just have read, my lord. My lord, if my lord kindly come to the Roman 2 at the bottom of the notification. Yes. The government saying allow the collector to charge advance royalty for 2021 for the volume of 50% of that previous 1920. So, my lord, the rate has been, my lord, reduced to 50%, half of the rate, considering the COVID period. So, that has also been considered. Now, my lord, kindly come Roman 3 of my supplementary affidavit at page 4. So, opportunity has been given and the COVID period has been considered. Now, my last remain that basis of the demand has not been uttered or said. I am coming, my lord. My lord, in similar manner, my lord, at Roman 3, notice meeting of 21, 22 has my lord, performed, occurred, take place, and my lord, rate was fixed. I am not reading, my lord. My lord, kindly come to Roman 5 at page 5. That whether the basis of the demand has been stated or not. My lord, each and every basis has been stated in my affidavit. Kindly, my lord, take paragraph number, serial number Roman 5. I am reading, my lord. That it is pertinent to mention that as per the aforesaid notification, the rate of royalty and cesses and the sand has been calculated at the rate rupees 3,11,302. Now, Myros breakdown is there within the bracket. Royalty plus cesses. For royalty and cesses, rate is fixed 2,39,802 and sand 61,500 for the financial year 1920. And the application fee was 5,000, my lord. So the total amount for the my lord 1920 was 3,11,302 plus 5,000 application fee. Total is 3,16,302. But my lord, what happened in the meantime? The BLRO concern, my lord, had I do not know, my lord. I have instruction. The BLRO concern, my lord, have done a mistake. When I'm reading, kindly see. But the concern BLRO demanded 2,93,627 instead of 3,16,302. So,
Where have you written?
my lord, Roman paragraph number 5 at page 5. So, my lord, mistakenly, the demand was wrongly placed instead of 3,16,302. Demand has been placed wrongly as 2,93,627. There is a mistake, my lord. I have stated it. Now, my lord, similarly, for the next financial year, I have also given the basis of my demand. That similarly, as per the notification, rate of royalty and cesses and sand has been calculated 1,90,100 for royalty and cesses, my lord, 1,27,400 and sand 62,700 for the financial year 2021. And the application fee was my 5,000. So, my lord, the total amount 1,90,100 plus 5,000 total amount 2021 is 1,95,000. So basically, but the demand was only 1,69,388 in lieu of 1,95,000. Yes, my lord, there is constant. Instead of my lord, appropriate demand 1,95,100, which my lord comes from this calculation, the demand has been wrongly placed, my lord. 1,69,380. And similarly, my lord, for 2021 also, my lord, calculated. I am not, my lord, reading. So, my lord, if my lord, kindly, my lord, next come to next paragraph. My lord, the next paragraph is stated, if any brief owners do not pay their dues, a penalty is to be imposed as per government notification. But kindly come, my lord, number 6. The payment of royalty and cesses.
So that is 1,69,388 is not a mistake. It is not a mistake.
But
it has
was only one in lieu of 195.
You say that it is a mistake.
The mistake, my lord.
Then come to page 2 of your report.
Page 2
of the report, not supplementary report. Paragraph 3. You say that has been reduced to 1,69,000. It is not a mistake. It has been reduced.
Yes, but that same has been discovered by the later on. Later on,
Reduced.
later on, because the same has been stated by the one after recommendation. It has been but discovered. And there is also no denial of the petition. That is.
No, no.
Now, my lord,
Has it been reduced due to the outbreak of COVID or it is a mistake?
no, reduction has been done, my lord. Reduction has been taken into consideration. That's why the royalty and cesses have been reduced to 1,27,000. Because when in the previous year the royalty had suffered cost and reconstruction the reduction down to minor 127 crore. So deduction for a has been given by, but there was a mistake and they see the demand. Now my lord finally come to my lord 1.6 of my supplementary. That's the royalty.
Yes.
Of my country. I don't, I don't,
That's very first exception. May I just read out? So, exception. The farm law.
It was the demand raised
2nd September 2024. Demand, lot demand was raised on page 45. 8th of December 2020. Yeah. I had stated now. At the outset, I most respectfully beg to state that I was never served any notice and or any intimation with regard to holding of any meeting of the district steering committee and or any other meeting at the behest of the district magistrate, elector, district with regard to fixation of royalty and cess in respect of excavation and or utilizing by spending on the minerals. The minerals themselves, the property beneath the soil, belong to the union. When the holder of a mining lease removes these minerals or consumes them, he can do so only on payment of its price or value. Therefore, expression royalty under section 9 appears to us a share which the union claims the minerals which have been pulled from the soil by the lessee and which otherwise belongs to him. No holder of a mining lease can say that what was lying beneath the soil becomes his own property merely by virtue of the fact that because of the mining lease he has owned it. It goes. I have missed the extra copy. I have one copy, but I can not take out a copy and give it to my lord's officer. I'll just read out that this is 1998, volume 6, Supreme Court cases 476. State of Odisha and others versus Steel Authority of India Limited. This is also on minerals, mines and minerals, Regulation and Development Act of 1957, the Central Act. But just putting one paragraph here. Paragraph 9. We have considered the arguments and the reasonings contained in the as follows. Or his agent, manager, employee, contractor, or sublessee from the leased area after such commencement at the rate for the time being specified in the second schedule in respect of the penalty. So, this figure, total figure, will not be emanate from those returns only. These are statutory returns we have filed to the respective departments, the GST and the income tax. All the three returns are part of my return.
Is it so that you are following Rule 35 for assessment of the royalty and cess as per the notification? No, he has shown the rule. Rule 35 is clear that whatever is extracted, on the basis of that, you calculate the royalty and cess. So, if one purchase 5 apples, then you get each apple cost ₹5, so 25 is the amount. So, if you calculate something and you don't calculate what is extracted or what is been taken out from the mineral, from the place of excavation, how do you calculate the total royalty?
Answered, or that cannot be calculated here and now, and that is also possible. Or that is I have to take instruction. But my lord, they have given the opportunity to run the business after paying such amount of royalty. But it is not the case highly considered that others have not paid and objected in this like fashion.
No. If others pay, then why he will reserve it? Is it so that 10 out of 10 persons, 9 make payment and one cannot challenge that?
one thing may I suggest, my lord, something for this correction. My lord, these are all now, my lord, after preparing this definition, my lord, coming additionally, these are all factual aspect cannot be decided in a limited scope, my lord. Jurisdiction, my lord, these are all factual aspect can be decided by the authority only because they have the if there is a calculation, they have the such calculation. Which
I
my
gave
lord,
him liberty to file a press representation before the authority to decide.
I do not think
Then that one is demand has to go.
no. They have already filed the representation and paid for this.
No. Both can go together. You demand me money, the same demand, and you are unable to show the basis. And then you
So
say,
directing him to disclose what has been extracted
my lord has granted
in
them
terms
two
of
opportunities.
Rule 35, and you clarify and find out what is the.
If there is any mechanism, so that can be my accepted. If there is no such mechanism,
There has to be a mechanism. How can you? You take instruction, come back tomorrow. There has to be. You have shown me the calculation in your report. How could you assess 3 lakhs something odd? Until and unless you say that such and such land has been excavated or extracted. You see Rule 35? Where is that? Yes. It is Dakanta?
But I'm showing. I'm showing mine. In fact, my lord, I understand that's next also. Next 4 of his report only. This is my next.
Hmm.
for actress decision.
No, Lord, Lord, kindly grant them liberty, let it come at least before your lordships. Again, we go back when the same thing happens, again I have to come to this on. They kindly keep the matter pending. He wants to take instruction. Let him come
These are
and show
all
the mechanism.
external point, my lord, which is not in the report.
No. No question. Lord, my very first point was that how they have averred.
My lord, adds us thing to the main report.
They have to no. It is your report. You have said how you have arrived at a calculation. You have to establish
Asha.
how you have arrived. Target fulfilling cannot be the mechanism, my lord. Your only
No.
ground is target
Even if your page 8 is accepted, he says that the rate is accepted. Yes. Supplementary or the rate. Even if rate, he accepts the rate. Now, what is the total excavation made on the basis of which the royalty has been calculated? Or we can go to annexure R4. It's again your argument, Mr. Shankar.
No.
I'm trying to make you understand one thing, that an apple cost 5 rupees. I purchase 5 and pay 25. Why should I pay 30? This is a rate given in the notification. His point of contention is that I have not extracted so much of land as this royalty or cess has been assessed. He accepts that rupees 83 and rupees 15 royalty and cess as per 100 cubic feet of the land. He accepts that notification. This is also accepted page 30. But what is the amount to be calculated? Do you understand? If the land, suppose the calculation goes like that, 58 per cubic meter, and the total land multiplied by that, it comes to 3 lakh something acceptable. But if you don't get that basis, then what is the basis of how you are arriving at 3 lakhs?
Actual quantum of my lord.
Land excavated, that is dependent on the total royalty, that is rule 35. That is the content. Because on Monday you come back, on Monday I'm fixing it, you take instruction, what is the basis of that calculation?
Kindly record this, my lord. This easy people take.
Yes. Yes.
Yeah. Awesome. Mr. Indranil Nondi, learned advocate for the petitioner, submits that the present writ petition has been filed challenging the quantum of royalty and cess assessed by the state authorities. The respondent number, which is the authority, sir? Respondent number 4, assessed by district magistrate and district collector, Purbo Mednipur. Respondent number 4.
Respondent number, this is magistrate 4, this is number 2.
2. He further indicates, referring to Rule 35 of the
Demand has been signed by the VLL advocate, respondent number. And paid 45.
quantum of royalty and cess raised by Block Land and Land Reforms Officer, Purbo Medinipur, respondent number 2. Referring to clause 35 of the West Bengal Minor Minerals Concessions Rules 2016, he submits that the royalty and cess to be paid by the holder of a mining lease is to be calculated on the basis of the mineral or minerals extracted or removed or consumed by him or his agent, manager, employee, or contractor at the rate as notified by the state government. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in 1998, Volume 6, SCC 476, and the decision of Honorable High Court of Gujarat reported in AIR 1979, Gujarat 180. Furthermore, the supplementary report So, records of the calculation arrived at by the state authorities. However, the amount of minerals excavated has not been disclosed. More so, no notice was ever served upon the petitioner of the meetings held on 16 September 2019 and subsequent thereto. In light of his aforesaid submissions, he praised that the demand notice issued by the state authorities is bad in law and requires to be quashed. Mr. On the contrary, Guru, Mr. So and so learned advocate appearing for state respondents at the outset submits that general notices were issued to the petitioner and the association to which the petitioner belonged, and such is the usual procedure. After due consultation with the owners and the association, respective associations, the royalty and cess has been calculated. আচ্ছা ওপরে একটা বলুন ওই যে ওনার সাবমিশনে the excavation was also affected by COVID pandemic. এটা ওনার সাবমিশনে থাকবে মিস্টার নন্দীর সাবমিশন। এবারে স্টেটের সাবমিশন চলে আসুন। He further indicates that the period of COVID pandemic has been duly taken care of by the state authorities, and for such period, the royalty and cess has been slashed down by 50%. Therefore, the petitioner is debarred from raising the issue that the demand raised by the state authorities is arbitrary, which in fact was duly arrived at after due notice. Para. Upon considering the submissions of the respective parties and also considering the relevant Rule 35, it is found that the supplementary report filed by the respondent number 4 does not specify the land excavated or extracted by the petition. At this stage, Mr. So learned advocate seeks to take appropriate instruction in this regard. List this matter on 11th. 11th August. তিনটে আমার hearing এ তো I think 11th. On 11th. 11th. Mr. Bandyopadhyay is also there with you. Okay, I have asked Mr. Pal to get an instruction and then intimate. Are extracted because his contention he has raised rule 35. So let that come, thereafter I'll dispose of this.
Item number